you all be seated, please?
Case before the court is a matter of the Republic of Remorra versus the Irish Republic of Arden. The applicant and respondent team are each allocated 45 minutes to present the respective cases.
Can I begin by saying that it had been intended that Her Excellency Judge Higgins would preside. Unfortunately, she has lost her voice, and under the circumstances, rather than relay commands by Morse code, it was decided that I would preside and relay her questions if the microphone does not pick them up. Can we have the appearances, please, first for the applicant?
Your Excellency, may it please the Court, my name is Douglas Guilfoyle. I will appear shortly for the State of Remorra, the applicant in this matter, and the principal agent, and shall be speaking for 21 minutes.
I'll have to ask you, Mr. Guilfoyle, to speak clearly into the microphone because it wasn't quite picking you up, though we did hear you on that occasion.
Certainly, Your Excellency. Is that better?
That is much better.
Certainly. As I was saying, I shall be speaking for a period of 21 minutes. My co-agent, Mr. O'Donnell, shall be speaking for 22, and we shall reserve 2 minutes for rebuttal.
Thank you, Mr. Guilfoyle. Ms. Echeverria?
Mr. President, Your Excellencies, I will be speaking for 22 minutes, while my learned co-agent, Ms. Claudia Molina, will be addressing the court for 21 minutes, reserving 3 minutes for the sole rebuttal.
Thank you, Ms. Echeverria. Mr. Guilfoyle.
Your Excellencies, may it please the Court. Remorra respectfully requests that this Court declare and adjudge that Remorra has a legal right to Mr. Tarak's extradition, either under the 1965 Extradition Treaty or the 1948 Genocide Convention, that the International Criminal Tribunal for the former Integra has no competing claim for Mr. Tarak, that Arden is obliged to customary international law to render up the proceeds of Mr. Tarak's war crimes, and that should Arden fail to comply with an order of this court to extradite Mr. Tarak to Remorra, Arden would be obliged to pay compensation. To this end, I, as principal agent, shall be making 4 submissions. The first, that the extradition treaty is in force. The second, that its terms require Mr. Tarak's extradition. The third, the Genocide Convention would also and independently require Mr. Tarak's extradition. And the fourth, that the complementary jurisdiction conferred upon the Criminal Tribunal by United Nations Security Council Resolution 1024 does not, in these circumstances, override the jurisdiction of Remorra's national courts. My co-agent shall be addressing 3 further propositions. That United Nations Security Council 1024 resolution is invalid, or that if in fact complementary jurisdiction would supersede the jurisdiction of Remorra's national courts, that grant of power is so disproportionate as to render resolution 1024 invalid. He shall also be addressing our submissions on the customary international law obligation to return the proceeds of Mr. Tarak's crimes, and our submissions on damages. To turn then to Remorra's first submission, that the extradition treaty remains in force. There is a presumption arising from customary international law in favour of the continuity of treaties upon the dissolution of a federation, such as the Federal Republic of Integra, subject to the expressed intention to the contrary of the successor state. It should be made clear that Remorra is not arguing that Article 34 of the Vienna Convention on Succession to Treaties is a precise codification of customary international law. We are arguing for a much narrower principle that would only apply on the utter dissolution of a federation. Article 34 is obviously much broader in its field of material application. We would rely for our state practice on this point of customary international law, the state practice in relation to the following dissolutions of federal countries: the dissolution of Greater Columbia, the dissolution of the Union of Norway and Sweden.
Mr. Guilfoyle, you say that you're not arguing that Article 34 is declaratory of customary international law. But I wasn't clear whether you were arguing that the rule stated in Article 34 was applicable to a narrower class of case, or that there was a different rule. Could you clarify that?
Your Excellency, we would argue that a rule with some similarities to Article 34 is applicable in a narrower class of case.
So that's a rule of ipso jure continuity.
We are not arguing, Your Excellency, for the universal theory of succession. We are
But the question is in relation to the situation. Are you saying that there is a rule or a presumption?
We are saying that there is a rule of customary international law giving rise to a presumption of the devolution of treaty obligations upon successor states when the central polity is dissolved utterly. Is that an adequate response to Your Excellency's question?
For the moment.
Certainly, Your Excellency. We would also draw the Court's attention to the dissolution of the Mali Federation, of Rwanda-Burundi, the Federation of Rhodesia and Nyasaland, the dissolution of Czechoslovakia, and the disintegration of Yugoslavia. In all of these instances, there was a presumption that treaties would remain on foot, and the world community acknowledged declarations, particularly in the case of Czechoslovakia, that in the case of both the Czech Republic and Slovakia, their treaties would remain on foot with respect to each party, except insofar as those treaties might impose unequal burdens on the two new states.
The respondent state hasn't made a declaration in this case.
Your Excellency, it is our argument that there is no requirement for a declaration of acceptance, but rather a rebuttal of the presumption.
But the respondent denies continuity.
Your Excellency, the respondent had three clear opportunities prior to these proceedings to deny continuity. One, when Remorra entered into the peace treaty with Nigeria, announcing to the world that it would regard the rules on succession to treaties as embodied in the Convention as applying. Secondly, when Remorra expressly requested Mr. Tarak's extradition under that treaty in paragraph 32 of the compromise. And thirdly, when Remorra denounced Arden's failure to extradite Mr. Tarak under the treaty. It did not do so on any of those occasions. In fact, in paragraph 34 of this compromise, the respondent state gave an implicit acknowledgement of the validity of Remorra's claim. It gave the clear impression that it had weighed up the two competing requests and decided in favour of the criminal tribunal. It made no denunciation of the continuity of the treaty. Indeed, its conduct in general appears consistent with acknowledging the presumption of treaty continuity arising upon the dissolution of a federal state, such as the Federal Republic of Integra. Alternately, it might be argued that extradition treaties are regarded as so intrinsic to world public order that there should be a special rule of succession in relation to extradition treaties alone.
Can you point to any element of evidence in favour of that proposition?
Yes, Your Excellency. One moment. Geoffrey Gilbert, in his ambitious survey of succession to extradition treaties in his aspects of extradition law, holds that in almost every case, including decolonisation, extradition treaties remain on foot. And it was said by this court in paragraph 186 of the Nicaragua judgment that to deduce a rule of customary international law, this court deems it sufficient that the conduct of states generally accords with the rule proposed. That also is, of course, support for opinio juris in the case of the state practice cited in relation to a special rule of presumption of continuity in relation to the dissolution of federal states. The treaty's terms itself, if succession has occurred, would certainly require Mr. Tarak's extradition to face trial in Remorra. Dual criminality is specified in Article 2 of that treaty, and it says that provided, subject only to the political offence exception and the non-extradition of nationals, provided the offence would carry a certain minimum punishment in both jurisdictions, extradition shall be granted. The language is mandatory. The question then arises as to whether Arden may legitimately refuse extradition on the basis of the political offence exemption.
Before we get to that, do you say that the words extradition shall be granted mean that the respondent state could not have exercised the option to try the accused itself? It was obliged to extradite, notwithstanding a desire on its part to try itself.
Your Excellency, with respect to the factual element of your question,
No, I'm asking you on the hypothesis that...
on the hypothesis that they are willing to try Mr. Tarak themselves, it would be Remorra's contention that, one, the language of the extradition treaty would give priority to extradition, and secondly, that Article 6 of the Genocide Convention would also give priority to extradition over domestic prosecution, perhaps occurring under Article 7 of the Genocide Convention. I'm sorry, Your Excellency, perhaps occurring under Article 5 of the Genocide Convention, the requirement to implement laws for the punishment.
Is there any authority for the proposition that extradition treaties take priority over the rights of a state to try itself? The normal situation is aut dedere, aut judicare. What you're saying is dedere takes priority over judicare.
Your Excellency, that proposition is made by Professor Bassioni is somewhat controversial and not substantiated necessarily at international law. There's been substantial debate between Professors Bassioni and Wise on the proposition that aut dedicare, aut judicare is a principle of customary international law, and most treaties stipulate which is to take priority.
The normal situation in extradition treaties is that the state has the option to try itself if it does not extradite, so that it is given some level of choice.
Yes, Your Excellency, but that's normally expressly included in the extradition treaty. There is no such express inclusion in these circumstances. Thus, looking to the political offence exemption and whether it can be applied in this factual context, Arden may not merely make an arbitrary determination as to whether it regards the political offence, these acts to be of a political character. It is obliged under the law of treaties, under Article 26 and Article 31 of the Vienna Convention on the Law of Treaties, to interpret and execute its treaty obligations in good faith. Remorra submits to this court that requires Arden to make out, on some test known to international law, that these offences can be construed as being of a political character. With regard particularly to the charge of murder, it is Remorra's submission that as a common minimum standard of the application of the political offence exemption throughout the world, that attacks upon civilians which are not directly necessary and proportionate to the political objective in sight cannot constitute a political offence. This is seen in relation to the three major tests adverted to by the eminent publicists in the field. These are, of course, the political incidence test as applied in the United States and in Britain, the proportionality or preponderance approach as applied in Switzerland, and the French theory of injured rights. On the issue, then, of the political incidence test.
Mr. Guilford, do you say that the respondent was under an obligation to extradite to you if it was clear that your trial of the accused would breach fundamental standards of human rights?
Your Excellency, there are 2 points to make in response to that contention. The first is that Remorra would contend that Mr. Tarak's trial would not breach any fundamental standards.
Again, I'd like you to answer the question.
Yes, Your Excellency, if I may first make out the factual basis and then the legal basis. On the facts, he will receive a fair trial. The eyes of the world are upon Remorra, diplomatic pressure is being brought to bear. 12 Nobel laureates have already intervened in this matter, and as was seen in the Eichmann case, when diplomatic pressure is brought to bear, when the eyes of the world are upon a nation seeking to try an accused war criminal, that a scrupulously fair trial can be expected.
Mr. Guilford, you say at page 9 of your memorial that Tarak committed crimes. You've committed yourself to the proposition that he's a criminal. How can you conduct a fair trial?
Your Excellency, I believe later in our memorial, under the consideration of the political offence exemption, we make quite clear that we would like those words, his acts or crimes be understood as shorthand for the acts of which he stands accused, for which there is a prima facie case. To return to your proposition that fundamental breaches of human rights would be a grounds for denying extradition. as we have said, we expect that Mr. Tarak will receive a scrupulously fair trial in Remorra. Whether the considerations of a fair trial apply in the case of an extradition treaty, one would require either a norm at the level of jus cogens, that fair trial prevails over treaty, or a rule of customary international law that, implied into every extradition treaty, is consideration of a fair trial. There would be insufficient state practice to support a read-in, as it were, norm of customary international law, simply because it has been found in the International Law Association's paper entitled Extradition and Human Rights, from the report of their 66th conference held in 1994, that some bilateral treaties take account of human rights norms. Most do not. The majority of states in the world do not consider human rights norms in the application of their extradition treaties. If Arden had wished to consider human rights norms in the matter of extradition, it could have entered into a covenant allowing them to do so, which could have been read alongside the extradition treaty, as happened in the Suring case. However, the Suring case only deals with rights and obligations surrounding a fair trial arising under the European Convention on Human Rights.
In the Suring case, the United States, the party requesting extradition, was not a party to the relevant convention. In this case, if it is said that there is a rule of general international law which prohibits a state returning a person to a place where he will be tried contrary to minimum standards of due process, why is that not in exactly the same situation?
Your Excellency, there are two responses to that question. The first is that in the circumstances of the Suring case, the parties to that case were, of course, Mr. Suring and the United Kingdom, and the issue being adjudicated was the United Kingdom's rights and obligations in interpreting their extradition treaty. On the matter of a customary international law principle, Remorra would again affirm that there is no evidence of even an emerging standard of a fair trial being applied into all extradition treaties. Such a standard is contained in the United Nations model extradition treaty we would concede, but that treaty has been put into effect by exceptionally few countries around the world, and in fact no state practice on that point is cited in the respondents' memorials. There is insufficient state practice to constitute a customary international law norm to inquire into the receiving state's judicial system in the application of an extradition treaty. Further, as we have said, Mr. Tarak will receive a scrupulously fair trial because the eyes of the world rest heavily upon Remorra. To return then to our contention briefly that there is in fact a common minimum standard in the application of the political offence exemption, the Swiss proportionality test holds that murder must be the last resort in achieving one's political objectives, and it must be directly and proportionately related to the end in view. Mr. Tarak's end in view was the toppling of an ethnically Remoran-dominated government. It was not proportionate to that end to engage in the planning of ethnic cleansing, widespread attacks upon the civilian supporters of that government.
Accepting that in relation to the murder charge, could you deal with the other charges?
Your Excellency, there are two responses to the other charges. If this court were to hold that they are political charges, they may be dismissed, and under the generally accepted principle of speciality, Mr. Tarak might still be extradited for murder. The alternate possibility is that when we consider the principle in extradition that one does not look to the formal denomination of a charge, but to the acts upon which the charge is made out. This is spelled out by Geoffrey Gilbert in his Aspects of Extradition Law, and is a principle applied in United States and British jurisprudence in cases such as the 1980 Governor of Pentonville prison case, and in the United States, the Oyenyan Choi extradition case. The principle being that if one looks only to the formal denomination of the charge, errors in translation may occur, differences as between two criminal justice systems may introduce unwarranted technicalities. The crimes alleged against Mr. Tarak, as spelled out in the compromise, are best understood as crimes against society, and on that basis the charges might be characterised as non-political. If I might turn then to our final submission, or the final submission I shall make, on the meaning of complementary jurisdiction. The definition of complementary jurisdiction at international criminal law is best provided in the draft statute of the International Law Commission's draft statute of an international criminal court. Your Excellency.
Yes, I would like the representative for the applicant state, before dealing with the question of complementarity, to elaborate on the scope of judicial review which is available to the International Court of Justice. In particular, I would like you to pronounce yourself on two questions. Firstly, can this court pronounce itself on the legal validity of Security Council action under Chapter 7 of the Charter? And secondly, in the event that the court deems that Security Council action under Chapter 7 has been unlawful, what effect would that legal determination have?
Your Excellency, both of those issues will be addressed at greater length by my co-agent. If I may indicate briefly the issues he should be raising, we shall argue that under Article 36(2)(b) of this court statute, it has the power to adjudicate all legal issues arising between the parties, and that the effect of a determination as to the meaning of Resolution 1024 will have the principal effect of resolving the dispute as to the jurisdiction of this court in this matter. If I may turn to the issue of complementary jurisdiction. The International Law Commission's draft statute of an international criminal court, in both its preamble, commentary to the preamble, and its commentary to Article 35, stipulates that complementary jurisdiction is not meant to override the jurisdiction of national courts or existing extradition arrangements. Indeed, it is only meant to step in where national prosecutions would be unavailable or ineffective. The elaborations upon this...
Or, Mr. Guilfoyle, where the Security Council so requires, because there is provision in the draft statute for the Security Council to step in and override, even though the statute does not do so itself.
Certainly, Your Excellency, but there is no evidence here that the Security Council has referred mandatory jurisdiction over certain offences to the Criminal Tribunal.
Doesn't it come down to the interpretation of the Security Council resolution?
Yes, Your Excellency, and that is why we are advancing evidence on the meaning of the word complementary. We would therefore argue that complementary, as it is contemplated by the International Law Commission, who formulated their definition a year before the resolution in question, indicates three situations where it's
nervousness, Mr. Guilfoyle. We shall give you 2 minutes when he says your time is up.
Thank you, Your Excellency. That's most generous. There are three circumstances where it would contemplate stepping in. If national prosecutions were unavailable because there was no functioning judicial system, if they would be, or if a nation were unwilling to prosecute a suspected war criminal, or thirdly and finally, if it appeared that in fact there were to be a trial with intent to acquit the individual in question, seeking to protect him under the rule of double jeopardy from further prosecutions. Those are the circumstances contemplated in the commentary to Article 35.
Surely the question is not the interpretation of whatever it is that the ILC might have done in 1994, but the interpretation of the Security Council resolution. On your interpretation, the Security Council resolution was saying that the International Tribunal's jurisdiction is subordinate to that of a requesting state, not complementary. Subordinate is not the same thing as complementary.
Your Excellency, concurrent means more than complementary, and concurrent jurisdiction which overrode national jurisdiction was granted to the Rwandan and Yugoslav tribunals in resolutions 955 and 808 respectively. Complementary jurisdiction must mean something less than concurrent overriding jurisdiction. It is Remorra's principal submission that on a natural construction of the language, in accordance with the only expert statement on what the law in such an instance might be, would mean that it would wait upon national prosecution, and where a national prosecution was in train, then the tribunal should not step in.
Yes, Mr. Guilfoyle, I would like to ask you whether the principle of concurrent jurisdiction would not be relevant in the present case, since your government has characterized the crimes as murder, treason, and sedition, whereas the indictment of the International Tribunal has characterized them as crimes against peace and humanity. In essence, we have two different characterizations of acts which may or may not overlap, how would the principle of complementarity operate in such a situation?
Your Excellency, I note I've exhausted
You
my
may answer
extension
the
of
question.
time. Certainly. Thank you, Your Excellency. Mr. Trask's indictment by the Criminal Tribunal stipulates that he stands accused of planning genocide. It has been noted in national court decisions, particularly Demjanjuk and Petrovsky, a decision of the United States Federal Court, that genocide may be a species of murder. And indeed, most national jurisdictions do not have a domestic crime of genocide and could only prosecute an individual guilty of genocide at international law under their domestic law for murder.
It's not a species of treason.
No, Your Excellency, it is not. We have argued that treason either need not be politically characterised or might be struck out of the extradition claim. If I've adequately answered Your Excellency's questions and there are no further questions, I would pass over to my co-agent. Thank you, Your Excellencies.
Thank you, Mr. Guilfoyle. Mr. O'Donnell.
Your Excellencies, in the 22 minutes available to me, I shall submit on behalf of the government 3 contentions. Firstly, that the United Nations Security Council Resolution 1024, which established the International Tribunal for Integra, is invalid. Secondly, that Arden is obliged under customary international law to render up the contents of Mr. Trask's bank accounts to Remorra as they are the proceeds of his crimes. And thirdly, that in the event that this court either finds that it cannot award specific performance or that Arden were to disobey an order of this court, then this court should award damages in the amount of $100 million for the non-extradition of Mr. Trask.
Mr. O'Donnell, you said the court cannot order specific performance. Can you give me some authority for the proposition that the court can order specific performance?
Your Excellency, I'd submit that there is no authority for that. It is merely adverting to a possible argument that my opponents may raise for not ordering Mr. Trask to be extradited, and hence that's when damage will arise.
So I rephrase the question. Is there any authority for the proposition that the notion of specific performance exists in international law? Or is it a municipal law doctrine known to some only amongst the legal system?
Your Excellency, with respect, I was merely using specific performance as a term of art to describe an order which demanded the extradition of Trask in person, as opposed to an order which a declaration and an obligation had been denied.
A term of non-art, Mr. O'Donnell.
I beg your pardon, Your Excellency, I was using the term to refer to that possible order. Turning therefore, Your Excellencies, to Your Excellency's question to my co-agent, and that is whether this court has jurisdiction to review Security Council resolutions. It is submitted, Your Excellency, that this court does have jurisdiction to review those jurisdictions, and that primarily this jurisdiction comes from the UN Charter and the statute of this court itself. Article 92 of the United Nations Charter provides that this court is the principal judicial organ of the United Nations, and Article 36(6) of this court's statute provides that the ICJ is the judge of its own jurisdiction. This court should decide these questions. But most importantly, Article 36(2)(b) of this court statute says that where two parties have submitted themselves to the ipso facto jurisdiction of the court, as is the case here, then this court has the jurisdiction to decide, and I quote, any question of international law, unquote, which is raised between the two parties and is necessary to be determined for the resolution of the dispute.
Isn't that simply question begging? The question is whether, under international law, the competence to review Security Council decisions exists. Simply to say the court has the competence to decide its own jurisdiction really takes one nowhere on this issue.
I agree, Your Excellency, that 36(6) simply sets up the argument that I'm making. It's Article 36(2)(b) that is the crux of that argument, and that is that it is one of the crucial issues that must be decided in this court, or a crucial issue between these two parties, is the validity of this resolution, because it will alter the obligations of these two parties. Because if the tribunal is invalid, then the only obligation which Arden has is to Remorra to render up Mr. Trask's body, either under the extradition treaty or under the genocide convention. And there is no superior obligation that might override that. hence the validity of Security Council Resolution 1024 is necessarily implicated in that. Your Excellency, some commentators have argued that there is no power of judicial review because of the Belgian motion during the Travail Préparatoire for the United Nations Charter, where a motion was put for the ability to appeal to the Security Council after a Security Council, to the ICJ, after a Security Council decision. I would submit that there's a distinction between appeal and review in this sense. It is admitted that there is no power for this court to review a decision of the Security Council as what might be described as an international equivalent of the writ of certiorari or a court of appeal. It's not possible for a disgruntled party to walk out of the Security Council chamber, travel to The Hague and ask for an injunction against that resolution. However, it is submitted that when the validity of a resolution arises as an issue which must be decided between two parties, then review in that sense is within the jurisdiction because of Article 36 2b of this court statute. I would further submit...
Mr. O'Donnell, Article 50 of this court statute says that the decision is only binding between... 59 says that the decision is only binding between the parties. How can a Security Council resolution be invalid as between the two states before us, but valid as against the rest of the world?
Well, Your Excellency, it would be that the declaration only has binding force between the parties. A declaration on the part of this court, a decision on this part of this court, which implied as part of its reason that a Security Council resolution's validity, that a Security Council resolution was invalid, would certainly have broad-ranging consequences, but it wouldn't have binding consequences per se as an order of the court.
What is the rest of the world to do then?
The rest of the world, Your Excellency, is then to behave, if it wills, on that basis that the resolution is invalid or not, depending on the general consent of states as to what is and what is not a valid resolution.
Mr. O'Donnell, if I may draw your attention to the following dictum of this court in the 1970 Namibia advisory opinion, where the court says, undoubtedly, the court does not possess powers of judicial review or appeal in respect of decisions taken by the United Nations organs concerned. How would you reconcile that with your position?
Because, Your Excellency, I would say that it is using the term review and in the sense of an appeal, in the sense of precisely the argument I was putting before, that this court does not have the power of what might be referred to as an international version of the writ of certiorari, the power to act as a court of appeal directly from the Security Council. It is submitted, though, that it can be said that Namibia allows review of a decision in a contentious case, because the Namibia advisory opinion, for one thing, went on, in fact, to review a Security Council resolution. And moreover, there are, and find it valid, and there are a series of judgments of this court which advocate the responsibility, a series of individual judgments which advocate that there is a power of review. Judge Spender and Judge Morelli in the certain expenses case, Judge Fitzmaurice in Namibia, and most importantly, the issue is left deliberately open in the decision in the preliminary measures to the Lockerbie decision. And in that decision, most notably, Judges Shahabuddin and Bajawi said that there clearly should be, advocated that there clearly should be a right of review. The issue, therefore, Your Excellency, is open on the jurisprudence of this court, and I will return then to my Article 32.
Before you do so, let me ask whether you haven't a little overstated it in the memorial when you said that in 1992, Lockerbie judgment, the capacity to consider the legality of resolutions was affirmed. We surely now know from the recent Lockerbie judgment that the issue is simply held over for the merits. I want us to know the answer on that one at all at the moment.
Your Excellency, I'm quite certain the intent behind that passage was that the possibility of reviewing Security Council resolutions was affirmed in the Lockerbie judgment. I could double check that because, but in any case, the submission that I'm putting to you now, Your Excellency, is that the issue is left open and that on the basis of first principles from Article 36 2b, this court should be able to decide that question.
But all the cases you've cited in which the court actually examined issues of validity were in advisory opinions, and surely there's a difference between advisory opinions and contentious proceedings.
Yes, Your Excellency, however, Lockerbie is not an advisory opinion.
No, but the point was it was not considered in Lockerbie and has not yet been considered.
Yes, Your Excellency, however, the court has deliberately left open whether it will or will not consider this, and there are at least two, and actually several more, but two leading
Well, perhaps you might address my question. Is there any difference between advisory opinions and contentious proceedings in this regard?
Yes, Your Excellency, although I would submit that it's not relevant to this situation, in the sense that an advisory opinion does act in a way as an appeal from a Security Council resolution, given that on the motion of the General Assembly or on the motion of the Security Council that occurs. I would submit that that isn't sufficient to serve the purpose of deciding issues as between parties, because an individual state can't ask for an advisory opinion, and quite often individual states' rights and liabilities are essentially affected by security grounds resolutions, and hence it would be submitted this court must decide those questions if they come before this court in order to do justice to the parties as between each other. On that basis, Your Excellency, it's admitted that when this court does review Security Council Resolution 1024, it is invalid, and it's invalid for 3 reasons.
Mr. O'Donnell, before you deal with those reasons, may I ask, surely there's a distinction to be made between judicial review in the sense that this court can review the legal validity of Security Council action as distinct from the proposition that this court can overrule, declare null and void Security Council resolutions. How would you reconcile these two different things in the present case? Can the court declare unlawful Security Council Resolution 1024?
Yes, Your Excellency, I would submit that the court has the power, in addition to interpreting resolutions, to actually declare them invalid, because that is interpreting in a sense
Such that they become null and void.
Such that as between the parties they become null and void, and that becomes part of the that opinion is then out in the international community, and it's up the nation's behaviour.
So the court can authorise a particular party to defy a Security Council resolution?
No, Your Excellency, because they wouldn't be defying a resolution because no valid resolution had been passed.
And therefore our decision binds the Security Council, which contradicts Article 59.
Technically, no, Your Excellency. Realistically, yes.
But doesn't that contradict Article 59? Doesn't that contradict Article 59 of the statute? The Security Council would then be bound by a decision.
Well, Your Excellency,
Either it's bound or it's not bound.
Your Excellency, the important distinction here is that while this court often makes decisions merely as between the parties, which have effects for third parties because they become part of the debate as to what international law is or is not, if it were to be held that any decision of this court which declares an obligation in general, whether in the fisheries case the existence of lines, and that's a bad example because it was...
Well, I think you've answered the question. Perhaps you proceed to
the point being that otherwise every case would have to be intervened by every nation.
Yes, we'll proceed to the question, the substantive question of validity.
3 reasons why it's invalid. Firstly, a procedural reason, Your Excellency. In the Namibia advisory opinion, it was said that the Security Council had to make the necessary determination, what some academics have referred to as to say the magic words or to invoke the magic formula. We have no evidence that that was done here, although we have no evidence that it wasn't done. The company doesn't give us enough details. It is submitted that this court under Article 50 of its statute should begin an investigation to see whether those words were said, and if they are not, this resolution is invalid at source.
The presumption, there's a presumption of validity, surely. The presumption is that the resolution is valid unless shown otherwise. So perhaps we proceed to the next point.
Certainly, Your Excellency. The second point, next 2 points deal with substantive invalidity. It is firstly submitted that there was no objective threat to international peace and security upon which the United Nations Security Council could have based Resolution 1024. And secondly, that even if there was a threat to international peace and security, it was so latent and so potential a threat that the action is...
How can this court second-guess the Security Council, which has the responsibility under the Charter on questions of international peace and security? Whatever issues of legality might arise, surely it's a matter for the Security Council to make those judgments.
Your Excellency, if this court were to say that it could never, under any circumstance, substitute its judgment for the factual declaration of the Security Council, then the concept of review would be without meaning. It is submitted that...
There are very significant potential areas of review, even if you were to reserve that sole area of an assessment of threat of international peace to the Security Council. That seems to be under the Charter, one area that's very specifically and consciously reserved to the Security Council. Does that not simply place this court in the position of an alternative body for political assessment? Are there legal criteria by which a threat to peace can be assessed?
Your Excellency, a compound answer to that question. Firstly, any exercise in judicial review that is submitted does involve a judicial body, to some extent, in second-guessing what could be characterised here as an executive body. generally there is a doctrine of deference, and I'm perfectly prepared to concede that deference should be given to the Security Council on these matters. But at the margin, whereas some judges of this court have said one could characterise a Security Council resolution as a mere figment of a pretext in order to invoke Chapter 7
But there's no
powers.
evidence that this resolution is a pretext or a figment, and beyond that stage, surely this court cannot go.
No, Your Excellency, it's submitted that beyond this state, this court can go, particularly when, if there is existence of a latent potential threat, as in where the measure chosen to deal with the threat is radically disproportionate to the existence of a threat. Because in order to fulfil the whole thing, if the Security Council may do
Where do you
something...
get radically disproportionate from? I mean, where is that in the text of the chart?
In fact, Your Excellency, I would submit that it can be drawn from the text of the Charter. Article 39 grants Security Council the power to make Chapter 7 measures, and I quote, to maintain and restore international peace and security. The grant of Chapter 7 powers are granted for a purpose and may only be used for that purpose. It is submitted that the internationally recognised means of determining whether a body has acted within a power that has been granted for a purpose is the test of proportionality. Various jurisdictions, most notably the European Community, use that. Moreover, there is some support for this idea within the jurisprudence of this court itself. In the Namibia advisory opinion at paragraph 110, where this court was dealing with the question of whether the Security Council had powers, general powers beyond the merely specific ones that it was given, it said, and I quote, that the Security Council has general powers commensurate with its responsibility for maintaining and restoring international peace and security, unquote. And it is submitted that commensurate in that case, this was a judgment in the 50s, is to some extent synonymous with the doctrine of proportionality. It's submitted that if Article 39 is to mean anything in saying that Chapter 7 powers may only be used to maintain and restore international peace and security, then by some measure, something that is allegedly done under Article 39 must have some connection to maintaining and supporting international peace and security.
You say some connection, but there was some connection.
Well, Your Excellency, it's submitted that the connection here, the cord between the two measures here is so thin as to have
So that's a
snapped.
question of judgment. And the Security Council is the body which has the power to make that judgment. We are not. It's a question of an expressly conferred power.
Your Excellency, I would submit that judgment is a matter for courts to decide as well as Security Councils, and that this body is the principal judicial organ of the United Nations, where a measure has been radically disproportionate to the end in sight. It is for this court to decide, and it is submitted that in this case the measure was radically disproportionate because at the time Remorra had a working judicial system. It was cooperating with Nigeria in order to deal with this problem of war criminals. If there is a latent threat that war criminals might, if this cooperation breaks down, give rise to international conflict, it is submitted here that this proposition relies critically upon how this court interprets complementary. If complementary does mean that the court waits on national jurisdiction, then that is entirely valid, we would submit, because we have a latent tribunal to deal with the latent threat. However, it is submitted that if the court has a superior jurisdiction, the tribunal has a superior jurisdiction, then the interference with state sovereignty implied by that act is so disproportionate to dealing with the latent threat as to make the Security Council resolution invalid.
Mr. O'Donnell, perhaps you'd move on to your next point.
Certainly, Your Excellency. Second issue, Your Excellency, is the content of Mr. Tarak's accounts. It is submitted that there is a principle at customary international law that Arden is obliged to render up the proceeds of crimes found within its jurisdiction to the state which best represents those individuals. This customary international law principle derives primarily from state practice subsequent to the Second World War with respect to what occurred to those assets looted by the Nazis which had been transferred to neutral nations. During the Second World War, in 1943, the Allies at the London Declaration, also known as the St James Declaration, declared that any wrongfully acquired property did not give rise to valid title at international law, even if transferred to innocent third parties. And this declaration was directed to the world at large, but specifically it was asked that the neutral nations note this. Resolution 6 of the Bretton Woods Conference in 1946, on the 22nd of July, also demanded the neutral nations return those funds which were the proceeds of Nazi looting. And in response to demands by the Allied nations that this be done, Most of those neutral nations complied. In fact, all with the exception of Argentina complied, and Argentina was a very minor recipient of, during the war, of the proceeds of these war crimes. It is submitted then, Your Excellency, that there is state practice and opinio juris, firstly because the vast majority of nations complied with the demand, and secondly because the opinio juris derives from the fact that a clearly a legal principle was called upon and adverted to, and that in response to that, the obligation was accepted by the actual monies being returned. This practice is in fact ongoing, Your Excellencies, and I'm sure this Court is aware the issue is of remaining assets in particular Switzerland is at this moment being decided.
Mr. O'Donnell, if I may ask, the standard for customary law in the jurisprudence of this Court is a virtually uniform and consistent state practice. Are you suggesting that the example of assets looted by Nazi Germany standing alone is consistent and uniform state practice? What would you make of the numerous other situations in which states have not cooperated in returning assets?
Well, Your Excellency, I'd submit that actually in most of the cases of wrongfully acquired looted goods, there has been a mechanism of returning them, but they have mostly been treated as what might be referred to as two-party problems. The UN Compensation Commission, with respect to the the Kuwaiti crisis, has been running for some years, as has the Iran Claims Compensation Commission. In most cases, it is possible in international law, where it's an international wrong, to bring the perpetrator state and the victor state before a tribunal, and then it is the perpetrator state's responsibility to get the proceeds from the third state. The situation here, of course, with Nazi Germany was important because they'd been invaded. It was difficult to deal with that question. And moreover, it's analogous here because of the three-party problem involved in these circumstances.
But the basis for the Iran U.S. Claims Tribunal is the bilateral treaty, and the basis for the Iraq Compensation Commission is a Security Council resolution. So is there a customary law basis with respect to any of those two jurisdictions?
It's submitted, Your Excellency, that there is a customary law basis to the extent that the prohibition on, for instance, plunder and pillage would exist as a customary international law principle, and also would exist because it's got the various conventions. The important point here, though, is that I'm distinguishing those tribunals from this situation, so they're not strictly relevant to this argument.
And would the seizure of food and weapons in the present case constitute pillage under international humanitarian law?
Your Excellency, on the compromise, especially paragraphs 15 and, if I have 1 second, 36 and 21, various items were being pillaged, not just food and weapons. Food and weapons is only the specific item that is being pointed to here. Secondly, the fact that it was submitted that military necessity would not justify the extent to which this pillage has occurred. If, Your Excellencies, I might turn briefly to the question of damages as the alternate claim. It is submitted, Your Excellency, that if, for whatever reason, this Court were to declare that Arden is obliged to return Mr. Ruck, but for some reason Mr. Ruck was not returned.
Well, Mr. O'Donnell, if the Court makes a declaration, the Court will assume that the parties will comply with its declaration. It will not discuss the question in the alternative.
Yeah, as I said, in that case the question is entirely moved. May I continue to...
What other points do you have to raise, Mr. O'Donnell?
All I was going to say was, Your Excellency, was how I found the $100 million as an amount.
You have 1 minute.
Thank you, Your Excellency. It is submitted that Remorra has suffered actual material damage if Mr. Tarak is not handed over. The prosecution of Mr. Tarak would be a major step, given that he is the self-proclaimed chief architect of the Remorran citizens' pain, to national reconciliation and redevelopment.
The respondent wants him prosecuted.
Sorry?
The respondent wants him prosecuted. The respondent has made a conscientious judgment that he would be better prosecuted in the tribunal established by the Security Council.
Yes, Your Excellency.
So what damage is there to you in the implementation of that judgment?
Because, Your Excellency, he would not be tried in Remorra.
So you're saying you have a legal interest valued at $100 million in taking revenge?
And also, Your Excellency, in re-establishing to the Remorran citizens by trying and, if he's found guilty, punishing the chief architect of their pain, that Remorra has a working law and order system. And the $100 million is a figure come to because in the absence of prosecution of war criminals or great architects of national pain, an alternate method is truth and reconciliation commissions, as has occurred most notably in South Africa, where instead of prosecuting those individuals who committed arguably crimes against humanity throughout the apartheid regime may instead introduced to treatment.
But why do we equate the total cost at a very large figure of a Truth and Reconciliation Commission with the value to you of your prosecuting him instead of an international tribunal established by the Security Council doing so?
Because there is
It seems a curious valuation.
Because there is, well, Your Excellency, firstly because there is a great value in Remorra dealing with its own problems, its re-establishes
From the
there.
perspective of this court, there is surely a value in upholding the determination of the Security Council.
But in determining damages, Your Excellency, it's submitted that the value that must be looked at is the value or disvalue to the party who is claiming damages. The damages done to us is the loss of opportunity of trying to run. The nearest substitute for that opportunity is the Truth and Reconciliation Commission. The Truth and Reconciliation Commission here is appropriate because Mr. Truck is the chief architect of these offences. And Truth and Reconciliation Commissions are extremely expensive organisations. In fact, we have very few figures, but $20 to $30 million was the extent of, if I might just finish
You
the
can
sentence.
complete the sentence.
$20 to $30 million was the extent of, for instance, the Chad and other South American and African Truth and Reconciliation Commissions prior to the South African one. And it's generally recognised that they failed because they were under-resourced. Moreover, it's submitted that to some extent this commission may be more expensive than the South African one because of the massive chaos and difficulty in finding evidence that would occur because the Remorran legal law and order system did not exist and had been torn apart throughout the conflict. On that basis,
Thank
Your
you.
Excellency,
It's a very long sentence, Mr. O'Donnell.
we submit ourselves to the jurisdiction of the court.
Thank you very much. Mr. Echeverria.
Mr. President, Your Excellencies, may it please the court. Your Excellencies, this case concerns the right of everyone to be presumed innocent until proven guilty according to law in a fair and public trial at which he or she has all the guarantees necessary for his or her defense, as well as the preservation of the rule of law among any circumstances. For this end, the respondent has made 4 submissions to this honorable bench. First, to declare that the extradition treaty between Arden and the former Integra is no longer in effect. Secondly, to declare that the proposed surrender of the RAC by Arden to the ICTFI and the ICTFI's jurisdiction to try this case is consistent with international law. Third, to reject any claims of Remorra for monetary damages. And finally, Your Excellencies, to determine that international law does not require the abrogations of Arden's bank secrecy laws in the case of the accounts allegedly held in the name of Malute RAC. I will be addressing the court for the first and second submission, while my learned co-agent will be addressing the court on the third and fourth submission. If I might proceed, Your Excellencies. In regards to its first submission, the government of Arden maintains that the 1965 extradition treaty has never been enforced between the Hellenic Republic of Arden and the Republic of Remorra. International obligations can arise either from a treaty or from international custom. There is no treaty between Arden and Remorra which definitely decides the issue of succession in this case. And there is not a rule of custom or international law that provides for automatic succession in all the cases of dissolutions of unions for all the treaties, Your Excellencies. In regards to my first argument, I would just like to remind to this court that the Vienna Convention on Succession of Estates in respect to treaties is not binding upon Arden, thus is not a party to said convention.
You've signed that treaty.
Indeed, Your Excellency. But as a signatory party, Arden is only bound to not go against the objects and purposes of said convention, and Arden is not going against those objectives.
Why is the disowning of a general extradition treaty not a contradiction of the object and purpose of the treaty?
Indeed, Your Excellency, because the object and purposes of said convention is to regulate the succession of treaties in respect to the succession of estates, according to the principles of international law. And therefore, it is Arden's submission that this succession should be, the succession of this treaty should be in accordance with the principles of international law.
Don't you you really have a much better argument, which is that there's no obligation not to act in disharmony with a treaty which is manifestly never going to come into existence. Why have you not chosen that argument?
Indeed, Your Excellency, it is Arden's submission that the 1965 extradition treaty is not more in effect, therefore it is not bound to...
No, but it is the 1978 treaty to which my colleague was referring. Are you planning to ratify the 1978 treaty at any stage?
Your Excellency, it is Arden's submission that the treaty is no longer in effect, and therefore, in order for this treaty to be binding upon Arden, the express consent of the state is to be needed. Your Excellencies, and in regards to my second argument that there is not a rule of customary international law that provides for automatic succession in all the cases of dissolutions of unions, I have first as an argument that the special rapporteur for the ILC regarding Article 34 of said convention has stated that that rule did not reflect customary international law, but that rather was a rule of progressive development.
What in your view, Mr. Echeverria, is the rule of customary international law?
Indeed, Your Excellency, a rule of customary international law has to have the two elements required.
Let me rephrase that. I'm not asking what it is in general. I'm asking what is the rule of customary international law if it is not Article 34?
Indeed, Your Excellency, as has been stated by this court in the Guinea-Bissau maritime boundary delimitation case, the rule contained in the Vienna Convention of 1978 that reflects customary international law is for boundary reasons, that is Article 11. But that applies only to territorial treaties. And indeed, Your Excellency, this treaty, which is an extradition treaty, is totally opposite.
It's certainly not a territorial treaty, but do you say that except for territorial treaties, the doctrine is clean slate? That you are entitled to reject all treaty relations between yourself and the applicant state?
Your Excellency, when there is absence of consent between the parties, then the case-by-case doctrine has been followed. That is, that the nature and qualities of each of the treaties has to be analyzed in order to determine whether the treaty can succeed or not.
So are you saying there is a presumption of continuity in that situation, which is then particularized by agreement between the parties?
Your Excellency, this has been very dealt between highly qualified publicists in between whether it's a clean slate rule that applies first or a continuity rule. But it has been widely dealt, and it has sustained that a continuity rule can be applied for multilateral treaties, but in that case there is not a presumption of continuity in cases of bilateral treaties. So, Your Excellency, this has been this was established in the Yugoslavian case, where the European Community Declarations and the Security Council resolution said that the succession of treaties should be dealt by agreement, or where it was appropriate, by arbitration. Also, Your Excellencies, in the Declaration of the Commonwealth of Independent States on December 1996, it was said that succession of treaties should be dealt bilaterally. Therefore, it is Arden's contention that without the consent of Arden, the treaty cannot be binding upon it. And in regards to the question that the applicant has raised, whether the treaty between Alicia and Remorra can be binding upon Arden, it is Arden's submission that by no means a third party can be bound to a bilateral treaty. This has been very well established in the North Sea Continental Shelf case, and also in Article 35 of the Vienna Convention in the Law of Treaties.
Mr. Echeverria, if I may interject, you suggested in your memorial that the doctrine of tabula rasa, the clean slate doctrine, applies to the state of Remorra. But how do you account for the distinction between states emerging from colonial regimes and the case of the former Integra? Surely you would not suggest that this is a case of decolonization.
No, indeed not, Your Excellency. It is Arden's mission that the dissolution of the succession of Integra was a dissolution of a union, but that the clean slate rule has also been observed in cases of dissolutions, such as in the case of Panama, in the case of Finland, the case of Poland and Czechoslovakia, the case of Pakistan, the case of Belgium, and in the case of the dissolution of the Mali Republic.
But surely an element of the tabula rasa doctrine in the context of decolonization is because of the oppressive nature of the colonial regime. It is a doctrine which wants to absolve the new entity or state from obligations which may have been incurred under an unlawful regime. But does the same apply to the former Integra, which was a state in good standing? Does the rationale for application of the tabula rasa doctrine apply equally?
No, it did not, Your Excellency. This is not the case of a decolonization process, but it is the Arden submission that also in cases where the continuity rule has been observed in cases of dissolution of unions, such as in the dissolution of the Greater Colombia, in the dissolution of the Kingdom of Sweden and Norway, and the dissolution of the Austro-Hungarian Empire, when there was treaties which were evidently personal, the continuity rule was not applied.
Ms. Secretary, can I ask you to proceed on the assumption that we hold that the extradition treaty is in force between the parties?
Excuse me, Your Excellency.
Can I ask you to proceed with your argument on the assumption that the extradition treaty is in force between the parties?
Indeed, Your Excellency.
If it is not in force, then clearly there is no problem for you, but let's assume that it is.
Indeed, Mr. President. In regards to the questions arised by the applicant's estate, it is Arden's submission that the political offense exception can be applied in this case. First of all, the 1965 extradition treaty provides in its Article 7c that the requested estate is the one who has to take the decision on whether the offenses can be of a political character or not. And moreover, Your Excellencies, treason and sedition are purely political offenses.
Both of those propositions are clearly right. The problem is that you didn't rely on the political offence doctrine. You relied on the proposition that these people were better tried by the Security Council's tribunal. That's a different proposition.
Indeed, Your Excellency, we did not propose the political offence exception because Ardens considered that the treaty is no longer in effect. But actually, Your Excellency, one of the main purposes of the political offence exception is to assure that alleged criminals have a fair trial. So therefore, it is linked with the second submission of the respondent state, that is, the ICTFI has jurisdiction to try Maluterrac. And also, Your Excellency, regarding the point of the principle audere adjudicare, which has been declared as a principle of customary international law by Judge Warramantry in the Lockerbie case, and it has been observed in many other treaties, especially in civil and the countries with civil law, it is Arden's submission that by surrendering Terrac to the ICTFI will be complying with the obligation adjudicare. Your Excellencies, so it is very important for this court to bear in mind that we are not giving political asylum to Maluterrac. We are pretending to surrender him to the ICTFI, in which he will have a fair trial, and if he's guilty, he will be punished according to international law. So, Your Excellencies, regarding Arden's second pleading, I will be dividing the pleading in two submissions. First, that Arden is entitled under international law to surrender Maluterrac to the ICTFI. And in second place, that the ICTFI has jurisdiction to try Maluterrac. In regards to my first argument, I would like to address for this court that Article 25 and Article 103 of the United Nations Charter makes obligatory to comply with Security Council resolutions when the states are members of the United Nations. Therefore, Your Excellencies, according to the United Nations, Arden is obliged to comply with Security Council resolutions. Now, in regards to the questions that the applicant has raised in whether the Security Council is able or not to decide when there is a threat to peace, the threat to the international peace and security, it is our submission that the United Nations Charter is very clear when it gives the power to the Security Council to decide on that issue, and that was also sustained by President Treble in the Lockerbie case, in where he stated that that power was only on the Security Council competence. Therefore, Arden, as a member of the United Nations, cannot challenge the jurisdiction of the ICTF, of the jurisdiction of the Security Council. Your Excellencies, also regarding the validity on the establishment of the International Tribunal, I would like to remind to this court what it was said in the Tadic case by the Chamber of Appeals in Yugoslavia. It was stated that the Security Council had the power in the circumstances to invoke Chapter 7 of the Charter, that it was an appropriate measure in the circumstances under Article 41 of the Charter, and that was in accordance with the rule of law.
Is that tribunal not exactly engaging in their statements in a judicial review?
Excuse me, Your Excellency.
What Judge Higgins asked was not the appeals chamber of the Yugoslav Tribunal precisely engaging in a judicial review exercise in the Tadic case?
Indeed, Your Excellency.
You rely on it, but you previously argued that it's a matter for the Security Council and not for the court. How do you reconcile those two propositions?
Your Excellency, this is only a judicial decision, and it's an opinion that by a judicial organ that the Security Council can exercise its Chapter 7 powers, creating these international tribunals.
But are you saying that judicial organs can decide that Security Council resolutions are valid, but not that they are invalid?
Your Excellency, I'm saying that what it has been stated is that the Security Council has the power to determine when there is a threat to international peace and security, and that was what the applicant state doubted regarding the competence of the Security Council.
On the question of proportionality, that is to say, the link between the finding of a threat to the peace and what is actually done, what do you say on that?
Indeed, Your Excellency, I would like to remind to this court that there was an international tribunal stated in Rwanda, and it was as after the conflicts in Rwanda had finished, and it was because there had been many violations to humanitarian law, and the Security Council considered that that was a threat to international peace and security. So it's not the first time that the Security Council made one of these tribunals. And in fact, the panel of experts gathered information in order to determine whether an international tribunal was necessary or not.
Mr. Echeverria, if I may ask, the atrocities, alleged atrocities occurred between March and October of 1995. Remorra declared independence in March of 1995, but did not gain United Nations membership until October of 1995, at which time a peace agreement had already been concluded. In short, there was no international armed conflict until October of 1995, when there was already a peace agreement. How could there then be a threat to international peace and security? And to the extent that the Rwanda conflict was a threat to international peace and security, it involved, according to the jurisdiction decision of the Rwanda Tribunal, a massive exodus of refugees into neighboring states. And my understanding is that the former Integra is an island nation, if I'm not incorrect, or perhaps that is Arden, yes. To which extent can one speak about a threat to international peace and security?
Indeed, Your Excellency, unfortunately, the compromise is silent on all the resolution 1024 in the compromise. So there is not the specific terms in which the Security Council decided why the conflict was a threat to international peace and security. But, Your Excellencies, the crimes committed during the Interan War was planning of genocide and crimes against humanity. And the peace treaty was signed after a multilateral force entered into the conflict. So there was not a peace between the parties, but it was that a multilateral force, the international community, had to intervene in that conflict.
So the presence of the multinational force is what you believe makes this into a threat to international peace and security?
Your Excellency, the presence of the international community in the conflict of Integra and the multilateral force in order to disarm the combatants in Integra was necessary, and therefore the international community had also to finish the conflict with an international tribunal.
So the factor of the genocide in itself would not constitute necessarily a threat to international peace and security?
No, indeed, the genocide is all, the threat of committing genocide is of course a crime against all humankind, Your Excellency.
So that's an independent basis?
Pardon me?
The genocide is an independent basis on which the Security Council could have acted in January of 1996?
Indeed, Your Excellency. In fact, genocide has been classified by the ILC in its draft statute as the only crime in which the International Tribunal can have inherent jurisdiction. So indeed, it's the world's most recognized international crime.
Could you proceed to the question of the interpretation of the Security Council resolution?
Indeed, Your Excellency. My second argument is that the ICTFI, having complementary jurisdiction, it has jurisdiction to try Malut the Rak in this case. Your Excellencies, the ICTFI is an international organ and competent to decide when to exercise its concurrent jurisdiction. Because even though complementary is also concurrent jurisdiction, but it is limited to certain cases. That is, when the national proceedings are unavailable or ineffective. Your Excellencies, as in the case of Rwanda, under the Rwandan statute and the Yugoslavian statute, they were capable of deciding when to exercise its concurrent jurisdiction. But also, the International Criminal Court, which will be a court invested with complementary jurisdiction, it has been established that it is capable to deciding when to exercise its complementary jurisdiction if the national proceedings are unavailable or ineffective. And therefore, Your Excellencies, it is all in submission that the ICTFI has made its decision to exercise its complementary jurisdiction, and that the request of surrendering for Maluta has been reviewed, and therefore, as a member of the United Nations Charter, of the United Nations, Arden should comply with the request for extradition. However, Your Excellencies, now that the applicant state has raised the issue of whether the complementary jurisdiction can be exercised or not by the ICTFI, I will present two relevant episodes to this honorable bench. First, that in July 1st, 1996, the Remorra Intelligence Service sent a band of commandos to Nailar attempting to kidnap the RAC. And secondly, that 3 NPA members were tried in a local court in Remorra. They were sentenced to death and executed immediately after.
The applicant's argument, as I understand it, is that you are under an obligation under the bilateral extradition agreement to extradite to the applicant, but that you merely have the power on the assumption of your argument, you merely have the power to transfer to the tribunal. Can you deal with the situation that you're in on that basis?
Indeed, Your Excellency, that is regarding the pre-existing obligation of an extradition treaty. In the instance that the court decides that the extradition treaty is still in force, we can apply Article 53 of the Statute of the International Criminal Court, which was dealt on December 1997 with regards to the parallel request of extradition between the International Tribunal and the request of extradition of a state with whom maintain an extradition agreement. It was stated on...
But that's merely a provision in a draft set of articles. It's not a provision in the statute of this tribunal, is it?
Your Excellency, the statute of this tribunal, unfortunately, is not complete on the compromise, but we can assume that since it's a court with complementary jurisdiction, the same principles can be applied. And this is not only the draft, but this was commented on the UN Preparatory Committee for the Establishment of an International Criminal Court on December 1997. And it was said that the requested state has to consider whether to surrender the criminal to the International Tribunal or to the state. But if the International Tribunal has sustained the case as admissible under its jurisdiction, then the state cannot refuse the request for surrendering to the International Tribunal. So, Your Excellencies, in regards to the trial of the 3 NPM members, it is our submission that even though Remorra argues that they had the right to appeal, they did not have the adequate time to appeal, which is also a recognized right. It was recognized in the statute of Rwanda, in the statute of Yugoslavia, and it is recognized also in this draft statute for an international criminal court.
If let me just interject quickly, you speak about inherent jurisdiction in the 1994 ILC draft, yet the Genocide Convention itself appears to apply the territoriality principle of jurisdiction, which in the present case would vest in Remorra. How would you reconcile your assertion with that fact?
Indeed, Your Excellency. First of all, the applicant's state is not requesting Arden for the crime, for the crime of genocide. And in second place, the Genocide Convention also prevents the establishment of an international tribunal, which at 1948, when the convention was made, was not existent. But that is why the ILC drafted in its statute the possibility of inherent jurisdiction in the case of genocide.
Mr. Echeverria, you have 2 more minutes. Could you answer the question in relation to the interpretation of the extradition agreement? Is it your position that, leaving aside the Security Council resolution, you are under an obligation to transfer the accused to the applicant state?
Your Excellency, it is our submission that the 1965 extradition treaty is no longer in effect.
Yes, but on the assumption that it is in effect, are we to construe it so as to impose that obligation?
Your Excellency, as I have stated, the 1965 extradition treaty contains in its Article 70 the possibility to the requested state to decide if the political offense can be applied or not. And Your Excellency, it is Arden's position that in the case at bar, there are certainly many elements in order to determine that the political offense can be applied in this case. So, Your Excellencies, if there are no further questions, I have concluded my statement.
Thank you very much, Ms. Echeverria. Ms. Molina.
Mr. President, Your Excellencies, may it please approve. As my colleague established, I am Claudia Molina. I will be dealing with Arden's third and fourth submission, which refer to Arden's rejection of any claim of remorse for monetary damages and the determination that international law does not require the abrogation of Arden's bank secrecy laws in the case of the accounts allegedly held for Mr. Tabak. In order to deal with the first of these submissions, Your Excellencies, I present three arguments. First, that Arden cannot be held responsible for surrendering Mr. Tabak to the International Tribunal. Second, that in the alternative, if this court finds Arden responsible for a breach of an international obligation, contrary to the disposition for the agents of Remorra, monetary compensation does not apply. And third, that the work of the proposed Truth and Reconciliation Commission has already been accomplished by the panel of experts, Your Excellencies. Arden's first argument is very simple. My learned co-agent has said that there is no binding obligation between Arden and Remorra, which requires for Arden to surrender Mr. Tabak to the International Tribunal and not to comply with its obligation to surrender him to the International Tribunal. Excuse me, just to let him over to Remorra. In the absence of a binding obligation, the three elements required in order to hold the state responsible under international law do not arise. The first element is the existence of a binding obligation and a failure to fulfill this obligation. In the absence of this...
Yes, Ms. Molina, you can assume that we understand those three propositions. But could you proceed on the basis that we were to find that there was some breach of international law and questions of evaluation were to arise?
If this court finds that Arden would breach an international obligation, Your Excellencies, monetary compensation does not apply, since, as it has been recognized by international tribunals, as in the Crawford case, in the Rainbow Warrior case, and in the Carthage and Menuba case, in the case of immaterial damage, as in this case, where the conduct of a state does not have a direct link with any loss or damage suffered by property or individuals, international law does not provide for monetary compensation, and satisfaction is the appropriate form of reparation, Your Excellencies. Precisely, the agents for Remorra have quoted in their compromise the Rainbow Warrior case in order to pay for compensation in the case of immaterial damage. Precisely, Your Excellencies, in that case, where there was a breach of an agreement where three French agents were to stay in an island in the Pacific, the arbitral tribunal decided that since this was immaterial damage, it did not entail monetary compensation, and the declaration of the violation in the judgment was sufficient, Your Excellencies. Therefore, satisfaction may take place in two ways. First, by the declaration of the violation of a judgment, as in the Rainbow Warrior case or in the Corfu Channel case, or by an apology rendered by the responsible state, as it happened in the Amalon case. Your Excellencies,
Ms. Molina, in the Rainbow Warrior case, New Zealand did not seek damages. It sought an order for the return of the individuals. And the court held that there was no subsisting obligation to return them. Hence, the question of damages for future conduct couldn't arise. New Zealand didn't seek damages for past conduct. This is quite a different situation.
Yes, Your Excellency. However, there is no precedent where there has been awarded damages, monetary compensation, in the case of immaterial damage when there is no moral damage or an injury to property, Your Excellency. So therefore, there being no right in international law that provides for monetary compensation in the case of immaterial damage, remorse claim should be dismissed, Your Excellencies.
But Ms. Molina, the applicant would say that there is serious moral damage. It has a right to try this person who is alleged to have committed dreadfully serious crimes on its territory over which it has jurisdiction. And it has been wrongfully denied that right by your conduct. On the assumption that that argument is correct, why is there no moral damage?
Your Excellency, if the agents of Remorra or as they established, that would be just a violation to Remorra sovereignty, as in the Crawford case, where no monetary compensation was awarded. If they try to see if they, as they said, they're claiming that the society would not have the opportunity of Mr. Tarak being tried, then justice would not come to the victims. But the International Court of, the Inter-American Court of Human Rights, in the cases of Velázquez Rodriguez and in the case of Alberto et al., as well as the European Court of Human Rights, in the case of X and Y versus Netherlands, have established that criminal punishment serves two main objectives. The first one is to deter further commissions of crimes, and the second one is to empower a sense of justice on behalf of the victims and those providing their rehabilitation. This will be fulfilled, Your Excellency, if Mr. Tarak is tried in the International Tribunal, so there will be no moral damage suffered by the Remorra society, Your Excellency. Your Excellency, and my third argument, Remorra has maintained that the money will be used for the establishment of a Truth and Reconciliation Commission, which, as it is established in their compromise under the third pleading of Remorra and on page 16 of the applicant's memorial, the Truth and Reconciliation Commission will be charged with investigating charges of human rights violations committed during the Integran conflict. Precisely due to this fact, I would like to draw this honorable court's attention to paragraph 19 of the compromise, where it is established that the Security Council created an impartial panel of experts in order to investigate charges of human rights violations committed during the Integran conflict, Your Excellency. These facts are relevant to establish that the work of the proposed Truth and Reconciliation Commission has already been accomplished by the panel of experts since they were invested with the same objective, Your Excellencies. In addition, the panel of experts is not the first precedent of these kinds of commission. The international community has established, after international conflicts or civil wars, commissions of inquiry, now commonly referred as truth commissions, Your Excellency, as it was as the one established by the Allied powers after World War I, to judge of the authors of the responsibility of the authors of crime, and after World War II, the commissions on the German crimes and the Japanese crime, and in the 19th, the commission for former Yugoslavia, Rwanda, and El Salvador, Your Excellencies. Therefore, this court should not underestimate the panel of experts' work and award compensatory damages in order to create another organ to fulfill the exact same purposes that have already been fulfilled by the panel of experts, Your Excellencies.
Isn't the applicant state, Ms. Molina, entitled to form the view that it needs a reconciliation commission to resolve these very serious problems that have happened on its territory, in relation to which the accused was the central figure?
Your Excellency, as it is established under compromise and their memorial, the Truth Commission will be established in order to investigate crimes committed during the Integran conflict. And the panel of experts was charged with exactly the same objective, Your Excellency, and in fact, they rendered their report on the 4th of January of 1996. So the same purpose or the objective of the Truth and Reconciliation Commission was fulfilled already, Your Excellency.
Ms. Molina, are you suggesting that the applicant is precluded from establishing such a commission, or simply that the establishment of such a commission would be redundant in view of the fact that a commission of inquiry has already been established?
Yes, Your Excellency, my submission is that there will be redundant. First, that there is no breach of an international obligation, and therefore we should not pay for the establishment of this commission. In second place, that if there's a breach, there is no material damage, so we shouldn't pay for the creation of this Truth and Reconciliation Commission. And third, that its work has already been accomplished by the panel of experts, Your Excellencies.
Is it not for a sovereign state to decide whether it needs still to do something further at the domestic level to ensure future compliance with human rights? Is that really to be taken away from it?
Your Excellency, there is no right to take that right away from the state, but as I said, criminal punishment serves two objectives, and one of these is precisely, as you said, Your Excellency, to deter further commissions of human rights violations in the future, and it will be served by Mr. Tarak's trial in the International Tribunal, Your Excellency. And in addition, Your Excellencies, we do not know how the state of Remorra come to an amount of $100 million US, since the sponsored UN Commission for El Salvador used a budget of 2.5 million,
and the former Commission for Yugoslavia used a budget for $500,000 US dollars, and an additional 1.3 million in contribution from 13 states and private foundations, Your Excellency.
Should use very expensive commissioners.
May I proceed with Arden's fourth submission, Your Excellencies? Arden submits that international law does not require the abrogation of Arden's bank secrecy laws in the case of the accounts allegedly held in the name of Mr. Tervac. Your Excellency, in order to deal with this submission, I present three arguments. First, that Tervac's impounding of the accounts was in accordance with Arden's bank secrecy laws, and in the same manner, the unfreezing of such accounts was in accordance with Arden's law. In second place, that the applicant never asked for the enforcement of a conviction that is a judicial decision that, in accordance with the emerging rules of international law, in this respect, would have been the only ground. Would have been the only ground to derogate Arden's bank secrecy law, Your Excellencies. And third, that now that the accounts have been unfrozen, complying with Remorra's request would result in the violation to the right of property of Mr. Tervac, Your Excellencies. With regards to the first argument, it was precisely, Your Excellencies, due to Arden's concern that the accounts found on their territory were suspicious and that they might have represented unlawful proceeds from proceeds from unlawful conduct, that it decided to impound those accounts. In accordance with Arden law, as it is established in the compromise, the accounts were deemed to be frozen and suspicious, pending proof by possible claimants that they were legally entitled to those accounts. Your Excellencies, the fact is that the accounts stayed unfrozen for more than 1 month, and no claimant came forward asking or showing that they had a legal right over those accounts, and that was precisely why a local court of Arden lifted the freezing of the accounts, Your Excellency.
But in the context of a state-to-state claim, the applicant's position is that it has the right to represent the owners of these stolen assets, and that it's not bound by your internal laws as to the procedures by which it pursues that claim.
Your Excellency, with all the emerging rules of international law in this respect, provide that it is precisely the governments who have to ask to the other government the enforcement of a conviction. They quote on their memorial, under page 20, the Financial Action Task Force recommendations, Your Excellency, and it is precisely the Financial Action Task Force 40 recommendations and the Ball Committee principles, together with the European Convention on the Laundering, Search, Confiscation and Seizure of Proceeds of Crimes, as well as the 1988 UN Convention, that establish that bank secrecy laws should not be used as a ground on the refusal to cooperate in the enforcement of a confiscation order. Your Excellency, the fact is that the state of Remorra never asked for the enforcement of a confiscation order, and that is of a judicial ruling, Your Excellency. So under even these emerging rules, if they are to be taken as customary international law, they clearly establish that the only way to abrogate bank secrecy law is with a conviction or a judicial ruling, Your Excellency.
Are you saying that the judgment that was given in the applicant's courts could have been enforced by the applicant bringing proceedings before your courts?
Your Excellency, this Rule 2, as it is established in the European Convention on Laundering and Search and Confiscation of Proceeds of Crime, established under Article 8.4, and this is followed by the 26 members of the Financial Action Task Force, that judgments which are rendered in absentia are not to be enforced, Your Excellency, or which are subject to appeal. However, Tervac could have appealed to that judgment, and if they are so sure that it's not Tervac's property, they would have gotten the right result and asked for the enforcement in the state of Arden, Your Excellency. And additionally, Your Excellencies, the government of Remorra has established that there is a customary rule of international law to return the proceeds from war crimes, Your Excellency. It seems that they have already convicted Mr. Tervac for war crimes, when in this moment we are deciding if he is to be extradited to Remorra or to the International Tribunal. They say, on the basis to prove that it is customary international law, the only two things that they quote is the restitution of the property that was looted by the Nazi Germans, Your Excellency. And precisely, yes, it is a recognized rule of international law that property which is unlawfully confiscated or expropriated is to be given back to the rightful owners, Your Excellency. But the state of Arden was not, as in that case it was Germany, it was not the state of Arden who confiscated property from the Remorras, Your Excellency.
But once it is established that this money was looted in the course of a conflict, notwithstanding that it's in an account in the name of an accused person, why is the return of that money conditional upon the conviction of the accused person? Why isn't that a separate question?
Your Excellency, I said that because they quoted that the property looted by the Germans, and precisely in that case, there has already been a treaty between the Allies and Germany, which the treaty provided that Germany was to redress all the wrongfulness that it had done, and that was why it had to restitute the property it had unlawfully confiscated, Your Excellency. But as I said, the emerging rules of international law in this respect do require the sentencing, the ruling of a judicial organ, Your Excellency, in order to abrogate bank secrecy laws and confiscate property, Your Excellency.
So, Linia, but in this case, it seems as if your government has suggested that it is not willing to discuss the matter any further. Is your government not at least under an obligation to make a formal investigation or inquiry as to how those funds were obtained?
Your Excellency, it is clearly established in the compromise that under Arden's law, it is possible claimants who have to prove that they have a legal right over them, and not the government of Arden who has to prove that the funds are unlawful. And therefore, since no possible claimants came forward to Arden proving that they had legal rights over them, it is not the obligation of the state of Arden to see if those if Mr. Tabak is legally entitled to them or not, Your Excellency.
But in a situation of some uncertainty and difficulty and with a distant state, you're saying that a month of suspension was a sufficient basis for any claims to come from the applicant state or from persons within the applicant state?
Yes, Your Excellency, and actually, state practice, as 13 of the 26 members of the Financial Action Task Force only give a period of 2 weeks, Your Excellency. So Arden considered that 1 month was sufficient time to allow claimants to come forward, Your Excellency. And now, Your Excellency, to conclude, I would like to establish, and that was my third argument, that now that the accounts have been unfrozen and that there was no proof that Mr. Tabak did not have a legal right over those accounts, complying with Remorra's request will result in the violation to the right of property of Mr. Tabak. The right not to be deprived of its property is recognized under the Universal Declaration of Human Rights under Article 17.
Ms. Molina, you say there is no proof, but all of the factual information before the court raises, at the very least, a very strong presumption that this money was improperly obtained, independently of the question whether the accused person was guilty of crimes against international law. He couldn't possibly have earned that money at that time in a lawful manner. Why aren't there sufficient grounds for an investigation into the origins of those funds?
Your Excellency, indeed, and that was precisely, as I said, why the state of Arden froze the assets, because it thought they were suspicious and that they might have represented proceeds from unlawful conduct, and that was precisely why Arden froze them. But nobody came forward claiming a right over them, and as I said, under Arden's law, it has to be Tabak does not have to prove that he has a legal right over those accounts.
But the applicant state has now come forward on a state-to-state basis, relying on international law and saying that in the situation in which there is strong grounds for believing this money was looted, there is, it asks for the return of the money. Presumably in the alternative, there is at least a strong argument that you engage in further inquiry.
Your Excellency, the fact is that Tabak's accounts have been unfrozen, and the state of Arden cannot freeze these accounts too, since there is no juridical cause to do that, Your Excellency.
But you can't rely on deficiencies in your internal law if there is an international obligation on you to return looted property. The fact that your bank's secrecy laws don't allow you to do it is your problem.
Your Excellency, but there is no international obligation requiring Arden to do so. And as it was established in the Lotus case, in the absence of an international obligation, a state is free to adopt any principle as it regards under its own domestic law, Your Excellency. There is no customary international law that would require Arden to do so, and even the emerging rules in this respect do provide that bank secrecy law should not be derogated unless there is a judicial ruling, Your Excellency.
Which you refuse to give or procure.
Your Excellency, they were frozen for more than 1 month, Your Excellency. So, and there was a civil conviction in the state of Remorra, and they did not come forward in order to enforce it.
Ms. Molina, were the accused convicted by the International Tribunal, would the situation change? Would Remorra have a better claim under such circumstances?
Your Excellency, the International Tribunal could ask to confiscate the assets due that there will be a pending trial, Your Excellency, and this is recognized too in the conventions, as I said. Yes, Your Excellency. I have concluded my statement.
Thank you very much, Ms. Molina. Mr. Guilfoyle.
Your Excellencies, the State of Remorra make the following submissions in regard to the applicant's case. Firstly, on the issue of complementary jurisdiction, Arden has not demonstrated that it is beyond this court's power to review a finding of the Criminal Tribunal that it has jurisdiction over Mr. Tarak. Further, Arden has not advanced justification for that assertion of jurisdiction within the grounds of the definition of the word complementary.
Mr. Guilfoyle, the argument is not just based on the word complementary. The argument is based on the word, the term complementary, together with a finding of this tribunal, assuming for the sake of argument that it is validly constituted, a finding of this tribunal that the accused should be tried at the international level. Surely that makes a difference.
Your Excellency, if the Security Council intended that this individual be tried at the international level principally, a grant of concurrent jurisdiction
Well, the
would have
Security
been far more
Council
appropriate.
intended, Mr. Guilfoyle, to establish a tribunal that would determine that question, and the tribunal has determined that question prima facie.
Yes, Your Excellency, but that decision is not unreviewable by this court. In the certain expenses decision, this court said that each United Nations organ is the principal judge of its own jurisdiction. That would appear to reserve a secondary category of review to this court. On the issue of succession, Arden has asserted that consent would be required in order for them to be bound. Addressing that contention, we referred in our main pleadings to paragraph 34 and an inference of implicit consent, but explicitly in paragraph 18 of the clarifications, Arden complied with all the procedural requirements of the treaty, which from its actions gives rise to an inference that they in fact consented. On the issue of the customary international law return of pillaged goods, money was recovered from third-party states in the World War II practice without determinations of individual guilt. If I may complete my sentence.
You may.
Merely, all that was required was a determination that the property in question was, in all probability, looted assets. Thank you, Your Excellencies. That concludes Remorra's case.
Thank you, Mr. Guilfoyle. Mr. Echeverria.
Mr. President, Your Excellencies, regarding the issue specifically of complementarity, it is Arden's submission that the Security Council invested the ICTFI with a complementary jurisdiction, and that the ICTFI is a competent organ to decide when to exercise its complementary jurisdiction. And furthermore, there are evidence in this case that provides for this court to agree that the complementary jurisdiction should be exercised. In fact, as the agent of the applicant stated, there is an international pressure in order for assurance of fair trial in the Maluta Raks case, and therefore it is a presumption of unfairness and therefore ineffectiveness in the national proceedings of the state of Remorra. Also, Your Excellencies, the applicant state has suggested that by rejecting the extradition of Maluta Rak, Arden has consented tacitly to the validity of the extradition treaty. It is Arden's submission that it is not likely to be presumed a tacit consent in regards to a treaty which the parties not considered to be bound. This was the view of this court in the North Sea continental shelf cases, and I also stated it is also in Article 35 on the Vienna Convention in the Law of Treaties that in order to be considered bound to a treaty, there has to be expressed consent, Your Excellencies.
Mr. Echeverria, if I may ask whether the accused will receive a fair trial in Remorra, is this a matter of unilateral determination by Arden, or is this a matter which should be determined by this court?
Your Excellency, as I have already said, this was decided by the this was decided by the ICTFI. But however, this question has been brought to this honourable bench, and it is this honourable bench who is to decide if the complementary jurisdiction should be exercised or not. And that is why I enhance all the evidence in whether a fair trial is, the Remorra courts are capable of giving a fair trial or not to Remorra.
You're suggesting, therefore, that a mere indictment from the International Tribunal presumes that the accused would otherwise not receive a fair trial in another state?
Your Excellency, the indictment was handed down after the trial of the NPA of the 3 NPA members in the local court of Remorra. Therefore, if the ICTFI can only exercise its complementary jurisdiction while the courts are not able or were unable or ineffective, therefore, if the courts of Remorra are willing to try Maluterrak, it is only possible that the ICTFI decided that its complementary jurisdiction should be exercised because of the ineffectiveness of the judicial proceedings in Remorra. Finally, Your Excellencies, regarding the argument of the German court giving the damages to other states, those the Germans' actions were held as liable, and in this case, Arden's action has no direct link with the loss or damage caused to individuals in Remorra.
Thank you very much, Mr. Echeverria.
Thank you, Your Excellencies.
The bench will now retire to consider its decision.
The Honorable Court is now adjourned.
Please be seated. Before announcing the result of the moots of the final, I wanted to first of all express the regret of all members of the bench that there has to be a result and that one team has to be, as it were, disappointed. It is in the nature of these things, but we were immensely impressed with the way you handled a difficult and somewhat diffuse problem. The way you did so was the more remarkable because you didn't have things which any lawyer would have, for example, the text of the Security Council resolution. And I would, as it were, as a unanimous recommendation from the bench to the organisers of the Jessup moot, suggest that in future they do the lawyerly thing and provide the teams with the actual relevant texts, rather than bits and pieces of them. However, on the basis that there was a fair bit of speculation necessarily involved, you all did really extremely well, and we were most impressed. Qualities which we felt all of the advocates had to a high degree were the capacity to speak to the bench and not simply to orate. So we felt that in all cases there was a personal contact, that you were responsive to what in many cases were some very difficult and even malicious questions. And though this is not a factor which was a major factor, it was, of course, immensely impressive that one team was arguing in a second language. To do that at this level is very remarkable. You all showed considerable command of the authorities in a number of different areas, and that again was of very high quality. There were some points on the substance. This court isn't asked, probably a very good thing in the circumstances, to give a judgment on the merits, but we felt there were some issues on which perhaps more consideration of some of the content arguments might have been given. For example, on judicial review, we felt there was too much focus on the essentially discretionary questions, whereas if there is any scope for judicial review of Security Council resolutions, it surely goes to fundamental issues of legality, which in this context really related to the nullum crimen principle and the radical uncertainty, of course, an uncertainty exacerbated by the failure of the organisers to tell you the content of the resolution, but nonetheless the radical uncertainty as to the actual offences which this tribunal had jurisdiction over. So we felt on the subject matter jurisdiction of the court there was very little that was said, and on the question of judicial review the focus was perhaps a bit diffuse. There was also perhaps a failure to make more of the point about the extradition of persons, or the right of a state not to extradite to persons to states where capital punishment may be inflicted. There's a series of decisions of the Human Rights Committee in cases such as Cox and Kindler which might have been given attention on that point. Another difficulty in assessing the case was that on balance the applicant state had the more difficult substantive arguments to make, and although obviously there were some particular points on which their task was easier, in general they were in a more difficult position, especially on such questions as the political offences doctrine. And to some extent we have of course taken that into account. Both sides were very good in rebuttal, in the rebuttal phase, although it's always noticeable that for the respondents going second there is usually very little to say, and to reserve as much as 3 minutes for the respondent in rebuttal is really something of a waste of. Well, having said that, I have here the award for the best oralist, and I'm delighted to announce that, and I should say that all of the decisions we've made today are unanimous. We've all unanimously found the decision agonizingly difficult, but we unanimously decided the way I'm about to tell you. And first of all, as to the best oralist, I'm carrying it out as long as possible. The best oralist, despite considerable competition, we felt was Mr. Guilfoyle. And that was However, I have to say this time it's going to make some difference. sit down for a moment. And I could ask Her Excellency Judge Higgins to make the presentations of the individual cups, which, unlike the major trophies, stay in the respective capital cities. And may I incidentally thank Judge Higgins so much for persevering, not feeling well, hardly being able to speak, and being nonetheless absolutely acute and to the point.
And then we'll get start partying. I have something to present to the winners as well, which is provided by LexisNexis, our official sponsor. They offer them an interactive courtroom training series on CD-ROM. Lastly, I would like to thank the
By the powers vested in me as Judge of the International Court of Justice just for today, and as member of the International Criminal Tribunals for the former Yugoslavia and Rwanda, should any of you wish to subject yourself to cruel and unusual treatment, I would invite you to apply to become law clerks at our tribunal. Thank you.
And lastly, I would like to thank the final bench. I was really pleased to have all the three of you here. You're all not here seated in Washington, D.C., so I really appreciate you volunteering here for our moot court competition. Furthermore, this is really the last thing I'm going to say. I hope you all had a good time here, and I wish you all a safe trip back. If you just wait for 1 second, I hope that someone is going to bring the free cards for Lulu's and the pens from LexisNexis over here, so that you can all get this small present from our official sponsor. I wish you all a safe trip back, and I hope you will be able to send another team again next year. Thank you.